A common adage goes that when two elephants fight, it's the grass that suffers. This best explains the dilemma in which the country finds itself in as the House folds its sleeves against Attorney General Peter Nyombi in a legal battle to find out who can best interpret the Constitution.
Our Attorney General all along has been acting partisan, so he's not the right person to give advice on the conflict between army officer and the civilian.
The cause of the controversy arises out of two articles in the Constitution, Article 208 and Article 113, which both talk about how ministers and serving officers can be appointed, plus another in the UPDF Act, Section 99, which explains how serving officers can seek for public offices. The person at the center of it is a former army commander, General Nyakairima, who is now more likely than ever to set record as the first army officer to take up a partisan job without retiring from the force since the 1995 Constitution came into force.
Can you imagine a situation where your commanding officer says, I want to know what happened in the cabinet, or I want to know those people who defied the order of the president. As an army officer, you are duty bound to reveal what happened.
Kanyeihamba says regardless of the Constitution, no single country under the Commonwealth law permits serving officers to take part in partisan politics without retiring from the army. He said the president risks being sued alongside the Attorney General if the two choose to use Article 208 and 113 of the Constitution to their own interest. 113 says ministers shall be appointed from among MPs or anyone who has that qualification with the approval of Parliament, while 208 says all serving officers shall be non-partisan, meaning they cannot serve concurrently in the army and in active politics. Another one is Section 99 of the UPDF Act, which says serving officers seeking to take up political roles must resign first from the army, though the Attorney General says this exonerates Aronda, who is not seeking any post. The contest is a waiver on the word of non-partisan in Section 208, and it is this that has drawn the line between who is objectively and subjectively guiding the country.
By serving in the government, does it mean that they become non-parties? Especially when you consider that the same constitution mandates the UPDF, the army, to be represented. For me, my interpretation is that government is not a party.
What is not at the issue is that, yes, an army officer is appointable to cabinet, but once he accepts to be appointed, or the authorities insist he should be appointed, he must resign his commission in the army. There are no alternatives to that.
One of the dilemmas the country will find itself in if Aronda becomes minister and also stays active in the army is that he will find himself with conflicting loyalties, since he will have a seat on the Army High Command and also in cabinet. Kanyeihamba now says the president should first explain to the country why he cannot allow Aronda resign from the army, yet he let General Jeje Odong to quit. He also wonders why the president himself did not choose to remain a serving officer when he became president. Now, this is not the first time that the Attorney General has come under criticism for coming out to interpret the Constitution in a manner which seems to befit the ruling government. It's a matter that has divided Parliament and probably divided the legal minds in this country. Moses, Rebel Television, Kampala.